something really good, a hot topic in the news this week. He's been charged with crime. This is a show where I try to educate real stories.
Thank you for watching Truth and Justice with Vivian King. I'm excited tonight because I have three beautiful women in the courtroom. I just left court, so I'm a little thrown off. In my courtroom, in Truth and Justice, to talk about running for judge. I hope that you agree with me and support the Year of the Woman, 2016. We're so excited about Hillary Clinton running. I boo-hooed and cried the night that the glass ceiling broke because I was a banker in the old days when there were very few women. In 1980, I was an internal auditor for a Fortune 500 company, and it was very difficult for women to crash that glass ceiling. I rose all the way up to VP, and I actually retired from banking in '89 to go to law school because I had bumped my head on that proverbial glass ceiling. And so, of course, when Hillary won the nomination, I cried all night. It was symbolic of women everywhere in the 70s and 80s who integrated the workplace that was formerly all male. And so I was excited about it. So I'm excited to support my fellow females that are running for judge because it's still a male-dominated world. It's still a male-dominated profession, the profession of law. If you ever saw any of our segments of Sisters-in-Law, you know that we are less than 2% female lawyers of the population, black female lawyers of the legal population. And I want to do my part to encourage women because we can make great sound decisions and be fair and impartial and be a great gatekeeper of the Constitution. So I will start with Judge Hazel Jones. And Hazel, I'm going to be asking a series of questions, but you're welcome to talk about whatever you like. Tell the viewers why you're qualified to continue to be a judge.
Well, I'm Hazel Jones, and I'm the Democratic nominee for judge of the 174th Criminal District Court. And I ran in 2008, and I would say the same thing today, and what's very important is perspective. I think that is a key to this whole, my whole platform is that that's the difference between a Democrat and a Republican. It's perspective, and it's always going to be perspective. And as it relates to me, as I stated in 2008 when I ran, I bring a broader perspective to the judicial court bench. And I say that because before I left law school at Howard University, I represented prisoners in disciplinary hearings. And so I had an opportunity to see what it was like to walk in a maximum security prison and represent people that were going to be there for 25 years to life. And I had an opportunity to hone my skills in the criminal justice clinic at Howard University, and I had a desire then to work in criminal law. So I came back home to Houston, and I started a career at the Harris County District Attorney's Office, where we had an opportunity to learn different skills, especially trial skills. I worked there for several years, going on 7 years, and then I left there and worked as a special assistant United States attorney in Harris County. And it was a big difference from leaving the state system and going to the federal court system. And what struck me for the most part was the Bail Reform Act that the federal government has, and how that act is written in the sense of trying to release the person that's accused. As you know, when you're accused of a crime, it's just an allegation. It still has to be proven by a certain burden of proof. And so the Bail Reform Act was just so different from being a prosecutor in Harris County, when really I don't think the prosecutors at that time, and I'm not sure today, really were focused on the purpose of bail. And it was more, in my opinion, at that time, just to keep the person locked up. That's just my opinion. But reading that Bail Reform Act and looking at each each point of the act it was just release. Can you release this person? If not, then can you put conditions on that person and release them? And so it went down in those steps until it got to the point, if you can't release a person, then okay, with no conditions that would satisfy the safety of the community and the return to court, then the person would be held in custody. So that just opened my eyes. And then being in the federal system, everything you had to do as a prosecutor. I was a special assistant United States attorney trying gun cases. I had an opportunity to try a case in every court there except for Judge Simlake's court, but I was in his court practicing as well. And so we had to respond to everything in writing. And so you had a lot of time to research the law and to understand different issues, especially constitutional issues as it relates to the defendant in traffic stops and the Fifth, the Fourth Amendments. And so you got a lot more experience as a prosecutor knowing the law. And so I worked there for a number of years, left there and worked as a criminal defense attorney. So I had an opportunity to try to work in Harris County and zealously represent defendants. And what I realized working as a defense attorney, it was an eye-opener, because I came back to a system that I thought was very complacent after being a federal prosecutor, understanding how much time you go into researching the law. And as a defense attorney, I spent time working and researching the law, but I found out
Nobody paid attention.
I had to start telling my client, well, the law is this, but I don't know if the judge is going to follow it. And I didn't like that. I didn't like feeling like I was subpar from the prosecutors. I didn't like the feeling I worked really, really hard and not knowing that the judge would follow the law. And that was very upsetting to me as a defense attorney, because I believe that I got my law degree just like the other attorneys did. And so I had an experience as a defense attorney where we tried a motion to suppress hearing, and the officer failed to make out probable cause. And after the hearing, during the hearing, we brought that to the attention of the court. I can't remember if we were going on to the next day. I think we were. And we brought that to the attention of the court, and then the court was like, oh, and let the prosecutor reopen their case. And then at that point, the officer was able to then come up with the probable cause to stop for following too closely, which is such a subjective. So I had a lot of experience doing 2008, and as a prosecutor and as a defense attorney, I guess that gave me a broader perspective of the whole judicial system. And then as a criminal defense attorney, just the experience of not feeling that I had my fair day in court with the judge really listening and coming out with a intellectually honest decision. And I had an opportunity to work as a judge. I was elected in 2008 as a state district judge here in Harris County, and had a lot of experience calling balls and strikes in the courtroom, clearing a docket of 900 down to the mid-600s, giving people an equal access to justice. I don't want to take up too much time, but those are the things that I say I can bring a broader perspective to the bench, because you want someone with life experience, someone that just didn't walk in the courtroom from being just prosecuting cases. All of that goes into how a person views evidence. How do you view the facts? That's based on my perspective. You may not view the facts the same way I do, because you may have a different perspective of what it shows. And so I think that's very important when you're looking at a Democrat versus Republican. What is that person's perspective? It has to do a lot with their background. It has to do with a lot of their experiences as a professional and life experiences.
Very, very good. You got my vote, Judge Hazel. So, Ramona, let me take you next. Ramona Franklin was also a prosecutor and is running for judge. Tell us why you're qualified to run for judge, or why you want to be a judge.
Why I want to be a judge. There are so many reasons why, but the main reason is, my motto is blindfold justice. And I really do mean that, because as you mentioned, I've been a prosecutor as well, and a criminal defense attorney. And so too many times when you walk into the courtroom as a criminal defense attorney and you realize that you're not only having to fight the prosecutor, you're also it seems like you're fighting the judge as well. Then you have your clients that you're having to represent, and it doesn't seem like, the judge has that blinder on, just like Lady Justice does, right? It looks like my client is measured up by the way they look, by how much money they have. You know, it seems like the decks are already stacked against them before we even walk into court. Not to mention, as a criminal defense attorney, I've seen too many times where my clients have been put into position to where they weren't able to afford a trial, which is really, really disheartening. And then the fact that you feel like you're in a fight, but you don't have all the right weapons. And what do I mean by that? For example, when I was a prosecutor, we had, you know, all of HPD. You know, we had all the investigators. You know, we had anything that we needed, you know, easily accessible. However, as a defense attorney, and you're dealing with clients who may not have that $1 million budget, then you don't have the weapons needed to go into this war. So you feel like you're fighting with sticks, and the other side is fighting with guns, right? And so that's one of the things that really troubles me with the criminal justice system. It's too many of our courts are being run by debtor's court. Just like Judge Jones mentioned about the bonding schedule. I'm really passionate about that. Having reasonable bonds. It's just too disheartening when you see people who, again, you've been accused, you've not been convicted, but yet you're in a position, if you're not able to bond out, if you're not given a PR bond or a reasonable bond, and you're left sitting in jail. And how many times, all of us know, how many times have we had clients that come to us and say, you know what, I just can't sit in jail anymore. Get me a deal. You know, and then your heart just drops and you're like, look, you know, let's try to work it out. But it's easier for me because I get to go home. Right. You know, but it's hard to try to tell a client, you know, let's try to stay in jail a little while longer until we can get you a trial date. You know, and then their family is looking at them like, well, you know, we need you to come to work. You know, you're going to lose your job. You know, and
your apartment,
your house. I mean, if you have a house,
get behind
your car,
on child support.
Right. You know, and so I don't like that part of it, and I don't like the gamesmanship that's played. I recall a lot of times as a prosecutor, you know, because the way it works at the Harris County DA's office, and I know you all well know, but we're talking to the audience, is that you're put into a particular court for several months. And so you become pretty familiar with the court staff, you know, the judge, and, you know, you talk to the judge, and, you know, but if you're a criminal defense attorney and you only come in that court maybe once out of a year, you know, the relationship is not going to be there. And so you have those ex parte communications, which are not supposed to have. But, you know, you'll find yourself talking and the judge will say, hey, you know, Attorney Franklin, how's that case coming? Are you all, you know, how are you all looking? Are we going to head to trial? That's ex parte. You know, and even something as simple, you know, as something as simple as asking, you know, what's the status of the case? To me, that still should not be discussed unless you have both parties there. So there are so many different things. And another thing, I want the sentencing disparity to be fair. I have too many problems with going into a courtroom and it's clear that you have two clients that have been charged with the same thing, have the same record, very similar record, but you'll have one person walk out with a pretrial diversion and you'll have one person walk out with the regular straight probation, which is a conviction. Or even if you get a deferred, you know, as if that's something great. Well, they still have the deferred, you know, as opposed to the pretrial, they can get that expunged, right? And I don't like that. So in my courtroom, the prosecutors are gonna know. We can't come in here with those sentencing disparity. If you're going to give Bill one sentence, you might want to give Hakeem the same thing. Because
I love hearing you say this. Let me interrupt for a minute because I'm excited about it, and I'm going to give you equal time, Ms. Hall. But let me tell you why I'm excited about what both of you are saying. First of all, with Judge Hazel Jones, when you know, I had a failed attempt to run, but one of the things I did since I'm the ex-accountant is I pulled like 15 years to the time I ran. So, and it was way before all of the Republican women took over. So let me backtrack. When I was a prosecutor, I lost more motions to suppress than I won. And that was just a few years before you. Wow. But that's an era you didn't know because that was before all of the prosecutors became judges. We had about 50% Democrats and 50% Republicans in 1992. And so Jim Skelton beat me every week in a motion to suppress, okay? He still teaches the classes on Wednesday. He whooped me every week. The judges listened wholeheartedly. Y'all don't know anything about that as Harris County prosecutors. We had to be on our game. We had to be ready for trial, and we had to look up the law. We didn't call appellate. We had to be ready to argue it when the judge called it. In fact, my first court I was in 1992 was Judge Barkley. If we didn't have, he might have 10 cases set for trial on Monday. He picked the one we didn't know as prosecutors, and if those witnesses wasn't there, he said, call your first witness. And if nobody walked through that door, not guilty. He called the case to trial. He was in charge of his courtroom.
Yes.
And that's what we were used to. All of them, Teresina, Barkley, I mean, I can name them all. Judge Love, the first felony court I was in was Judge Love, the real Judge Love. And so that's now the ceremonial court. He was elected as judge the year I was born in 1958, but he was still walking around. And so he was the 177th District Court. So I'm just saying, they did not give us special treatment. In fact, they leaned over backwards for the defense, which is the way you learn about it in law school.
Yeah. So the question is, what changed?
What changed was in, well, November, I lived through it. November 1994, I'm a prosecutor, but I'm having my baby. That's when the Republican sweep took over. And January 1st, 1995,
new day.
It was a new day. All those Democrats lost. And it changed, Debbie Mantu Strickland was there, Belinda Hill, Joan Collins, Joan Campbell, and they were tough as nails. I mean, they came in and they would take no prisoners. When we were there, 50% of the people who had ag robberies got probations. All Judge Keegan would say in the back, I got probation. Judge Keegan was still there when that sweep came, but she died right then. So she was there, and that's how Belinda Hill got appointed. So she was still there. They didn't sweep her out, but she was still there. And she might have been one of those Democrats that switched sides, too. I can't remember because I was too new. But when I left the DA's office in 95, I remember going to her, and she would let you go in her chambers, and both sides would be there. And they would say, is it a bad ag robbery? That's what she'd ask the prosecution. And as long as nobody got hurt, they pulled a gun, but nobody got hurt. She said, all right, I'll give him probation. And I think I probation. It wasn't that big a deal. And she didn't know me from Adam because I was never in her court.
And deferred used to mean something.
And it used to mean something because there weren't computers. But right around the time I started in 1992, they hired all those key punch operators, if y'all used to hear that term, and they took all of those old files and put them in the computer. They weren't there. And deferred adjudication, because it wasn't online, people didn't know what people had. You'd have to actually go down to the courthouse to actually see it because they had. So it was a different day. So you have to know how disappointed I was when just 2.5 years I started 3 to 4 years I started practicing defense law, and I have to watch all these ladies who I was a former prosecutor with, who've taken over, just slamming people. I would see judges high-fiving each other in the hallways after they gave the most time. Oh yeah.
That's
yeah, people y'all know. And I'm just sitting there going, I used to boo-hoo and cry. So when I ran for judge, being an ex-accountant and auditor, I paid for the Open Records Act to get from when I ran in for the 185th, and so what was Carl's?
Walker?
Carl Walker had been in there. So I went from like 5 years to him being there to when Susan Brown took over, and then all the way to the present. It was like 15 years I paid for all 22 felony courts to see the bonds, how many times they gave bonds for the year. I paid a couple $100s for this. Really? And I actually won the Chronicle's endorsement because I said, when I come, I'm going to change the bond schedule. Good for you. Because I had started doing federal cases in 1999. 4 years after I left the DA's office, I won my first federal trial. So I got to see the presumption of, unless it was a drug case, it was no presumption of flight. It was a presumption with the bond.
You could go home.
Act to let you get out.
You could go home.
And you didn't have to pay a bondsman. And if you didn't have the money, it was based on how much you had. So I knew, and I love the scheduling order from federal. I hate the fact that we treat people like cattle. And so I said that in the interview. I said, look, I'm going to give a scheduling order. It's going to be for the lawyers to meet and exchange information, and they're going to have to come at pretrial conference, just like federal. I was going to do it just like federal. Pretrial conference or trial, unless the lawyers, once they get together, I was going to still have, monthly meetings where the lawyers exchange information, and then if they wanted to plead their client, they set it for a plea, just like in federal. And I was going to set it for a specific day on Fridays. And I was just going to do it from the moment I took it. Wasn't going to be retroactive from that point on. And I was going to give people reasonable bonds. On that first date, I told them I am going, and I gave them the statistics. Susan Brown had never given a bond. And she had been on the bench about 15 years at the time.
When you say never,
Never?
exactly
Zero.
what do you mean?
Zero. Every year from her election, from the time she got on, January 1995, all the way to when I ran was 2010, there had never been a bond. Given. Zero. It went zero. Carl Walker's had 200.
To be clear for the
50.
viewers,
Okay.
having never given a bond means that all of those people
Pretrial
were...
bond. Okay, that's what I'm trying to say. Pretrial bond.
Okay, 'cause
I
I'm
did
like,
say
wait
it
a
wrong. I did
minute.
say it wrong. See, y'all know I'm tired. No. I'm so sorry. I'm so sorry. I'm very exhausted because I'm in 3 weeks of a
No, we
5-week
got
federal
you.
court.
No, yeah.
I meant a pretrial
But hey,
bond because I think pretrial bonds need to be used in felony too, especially for the I was there when there was no such
accused.
thing as state jail felony. So we, everybody was, when they created it, I read the legislative history. They wanted the nonviolent people to be able to get out because back in those days, anybody that had less than 28 grams was a third degree. We only had first, second, and third degree. And so people would come in with crack pipes and they'd be getting 25 to life. They'd get 25, 50. And so people were just shuffling in and out. They did 6 months in jail, on 20 years, because, and so the legislature to handle that created the state jail felonies and they designed it for forgeries, thefts, and nonviolent crack pipe cases. So they would have this system where it was not enhanceable at first. And every year that law got changed by the lobbyists from the district attorney's office.
Of course.
They changed the law.
More and more
so
punitive.
more and more punitive, and it wasn't designed that way at all. So that they could stay in a facility that was for lockdown with no parole, and if they had a drug problem, they could seek treatment there while they stayed there from 6 months to 2 years. And so it was just a different time. Actually, when I was there, habituals got Senecor all the time when I was a prosecutor. They were 25 to life.
Wow,
The
things
judges
have
used a lot of Senecor. And they also, because it was still Ann Richards. She got defeated in 1994. And Ann Richards had all of the programs where if they could, instead of going to prison, there was an alternative to incarceration. They could go to drug facilities and live in drug facilities. It was totally, the day Bush Sr. won, all that was cut. Everything changed. And maybe we don't need all of what we had, but it would be great to at least have some type of
Balance is good.
balance to see what works, especially for the nonviolent offenders. So let me correct it. She didn't give any pretrial bonds, zero. But Carl Walker had given, say 200, 500. I don't remember now, but he had been giving them to the nonviolent offenders, and that's where those conditions, because one of the things most young lawyers don't know is our pretrial services was created to release people.
Right.
Yep.
It was as a result of a federal lawsuit that was holding people in jail. And the way the judges used it was to add conditions to their probation.
That's right.
A person should be able, y'all, I'm just going to tell you ladies, and I'm going to be mad when y'all win and y'all do this, to post a bond and live their life. Unless
They are only accused.
all the
They're
bonding,
only accused.
all the
They're
bonding
accused.
companies need to have to at least warn them of what's going to happen, because I've watched too many judges take them into custody after making a bond, and the bond is the agreed bond schedule for the 22 judges. The bonds that are set
Dictated.
when someone's arrested, the 22 judges have voted on that bond schedule.
Yes.
So then why would you get to Jan Crocker's court
And it's different.
and then she calls you up on probable cause and says, "Oh, what is the bond on yours?" And now, it's 20,000. Oh, I'm gonna raise it to 50,000. Go back into custody. She used to do that a lot. I'm not sure if she's doing that anymore, but she did that for years because she's a part of that group that came in. She did that for years and years, and it would always be on a minority. It would always be on someone dressed nice. Thought they had.
What I said about
Thought they had.
blindfold justice.
Thought they had followed paid a bond.
Power.
And it's
Why is that tough on crime always tougher on the minority
Or the
or
poor.
socioeconomic deprived?
And I understand there are some precautions that need to be taken if someone is accused of a violent offense. I think
Or if they're a genuine flight risk, which is rare.
genuine flight risk.
Rare.
Right, which is
I've
very
seen
rare.
the
Like you said.
disparity in pretrial diversion, and so one of my pet peeves is that needs to be changed. I don't think the prosecutor should have just carte blanche on who gets this pretrial diversion. I distinctly remember being on the bench, and I always want to know, why are these certain people so special they get this pretrial diversion?
Certain judges, not judges, certain defense lawyers, whenever they come in with
yeah.
the
Yep,
client.
if they're friends
yeah.
with
They're,
the right people.
They're automatically.
And when I was a prosecutor, which was before you guys, only the River Oaks kids got it.
Well, I started
And
questioning
we fought
that.
a lot, and so Pat Lycos was the one that started letting regular kids get it.
Well, I started questioning that because I just want to know. So when they came in front of me with the pretrial diversion, I'm like, well, why is this person getting pretrial diversion? Because I wanted to know what
Right,
made
what's
this
the
person so
reasoning?
special.
Yeah.
Because I knew just my experience as a prosecutor, having told this one defense attorney, no, your case is set for a plea, we're not going to do pretrial diversion. And the next thing you know, they went to someone higher
than you.
and they got the pretrial diversion. So I always wanted to know what's so special. I would ask that question, why is this person getting pretrial diversion? And so I was kind of amazed to find out some of the reasons why, which included,
Are you amazed, Judge?
I was.
What were some of the made up?
One was he's a well-known florist in the city. I'm like, okay.
Wow.
Still a criminal.
One, now these were older people. These were people like 40s,
Right.
Probably late 40s.
People that really
And-
didn't need it to.
Well, that's-
a florist doesn't need it to have his record
right.
claim.
That's not the purpose I thought.
Exactly. Well, they told us when the River Rose kids got it, well, his daddy's a doctor. He wants to be a doctor, so he'll never be able to become a doctor.
But let me
if he
tell you the
has
rest of this.
Yes, ma'am.
Then I found out about another woman. Why is she getting it? Well, because her son is a all-star player in, at high school. I'm like,
What does that do with
okay.
the mother?
What, she's got to
Right.
take him to practice? Or?
I couldn't remember the reason. But what really got me is I was kind of very taken aback and upset because we had a young African American. Now, the others were not African American. They were older Anglo-Saxon people. And we had an African American male come before us, and it was an issue of pretrial diversion. And at some point, it was he's just going to do a deferred. And so my understanding was that he did not, he wasn't accepted. He didn't get the pretrial stamp of approval.
Surprise, surprise.
So I didn't know the details. We gave him the deferred. I didn't know anything about really the facts behind the case. But lo and behold, I want to say, I don't know if it's a few days later, a week later.
Motion for new trial?
No. My coordinator says, there's a news media that has interviewed so-and-so about who he is.
The defendant?
Yes, and they had a whole news show about how he was a young African-American high school student who was homeless at some point in time and who had just gotten a scholarship now to go.
And now he can't go.
Well, it was possible for him to go, but the point was, isn't this the type of person you want to give
Exactly.
a pretrial
And the
diversion
reason why I'm
to?
interrupting you, excuse me for doing that, is because I remember when Lot Brooks' son kids were in college, they told me if they're on deferred, those kids don't get their scholarships. That's one of the reasons why you get pretrial. Some schools don't want you to be on any
Depends on the
paper.
school.
Period.
But they don't want you to be on any paper. They want you to follow their rules and they want you to go to school and they don't want you to have that 20-page, 20-document contract that's going to require you.
Right.
So I'm not sure if it's because they're on deferred or it's because they don't want them to have that obligation. Because it's a school's intent, if you're going to play football, is that you got to,
Be there.
and you got to try to get tutors and go to school. It's hard enough to manage those two jobs.
Right.
You can't have a third one. It's unsuccessful. So I know that there was an issue that he told me about kids that he knew of that their scholarship, right now the rules are their scholarships.
Really?
And I had a track star that I did get pretrial diversion from under Pat Lycos when I made a big deal. He was a poor kid, but I made a big deal. I said, Pat, it's time to stop the racism and the classism, and they let him have it. But I went all the way to the top. I fussed because I know Alvin Nunnery was very upset a few years ago. He tried to get one for a pharmacy student. They wouldn't give it to
my
him. Black male,
gosh.
pharmacy student. And there was no reason why this guy couldn't get it compared to
when
all the other people.
You think of the consequences, all of the collateral consequences to the accused. The notion for all of the pretrial diversionary projects, programs, even the stuff we have now with drug courts and star courts, which most people don't realize, felony accused can get diversion for drugs and prostitution and theft and other things. The idea is, what's the long-term effect on society? What's the benefit of punishing somebody in such a way that you absolutely positively will disenfranchise their entire future? Well, we usually say there's no benefit. You take a pharmacy student or a successful ball player. I mean, look at the rationale we got for the young rapist. We were concerned about his swimming career from the bench. The dude from Stanford.
Yes.
The judge actually said from the bench, his future matters because he was a swimmer. Well, it's because as a society, we have said that if you're in school, if you're productive, if you're employed, we celebrate that. And if we think it's a good risk to let you continue that by not giving you a record, we want to do it. So what happens in the evaluation?
It's all about perspective.
It is.
It's all about perspective.
Which is
That's
where
a
the
good
diversity
idea.
comes in.
Let's talk about the civil bench that you're running for. Future judge, well, I can call you judge now, Judge Hall.
Yes, I'm a municipal judge for the city now and have been for over a decade. I'm going on my 11th year in this
right.
court-appointed position, which is quite unique because we handle all of the city ordinance violations as well as misdemeanor accusations along with the JP court. So it's technically a criminal court, a state court, where we use all of the rules of procedure and evidence that apply to state courts. But we handle predominantly traffic, but also, as I said, Class C misdemeanors. So it's an extraordinarily interesting way to get an overview of people's court, if you will, baby law, the kind of thing that so many people, so many criminally accused have to deal with that seems inconsequential to others. It was a time when a Class C misdemeanor would mean nothing. Now it means so much because everything is digitized and there's nothing that's unavailable to the public in your record. But I, most importantly, have been a sole practitioner for the last 21 years.
Wow.
And I think that the sole practitioner's perspective in practicing in Harris County is quite unique because in general in the civil courts, it is institutional practitioners that get the most press, that get the most good treatment, that get in my opinion, very unique opportunities, for lack of a better word, from the courts. And so my interest in being a judge stems from the fact that I know what it's like to dispense justice because I've been doing it for 10 years. I wanted to save the world when I went to law school, and it took a time to realize that justice is expensive and hard to come by and complicated. And so my time in the municipal bench in Houston, which is one of the most diverse municipal courts and one of the largest in the country, second busiest, I've been able to see the value of a diverse bench. And the truth is, while we often assign morality to other things, diversity has in its core its own type of morality because the truth is, as everyone has mentioned, perspective makes a difference. Whether you are person of Islamic faith, whether you're a person who is male or female, whether you're a person who is physically handicapped, a person who is straight, gay, transgender, or bisexual, a person who is young, a person who is old, a person who plays sports, a person who, anything, any category you can develop for human beings is of significance in the way people look at things. And so for me, in my long time practicing, what I hoped for every day was some diversity because for the most part, it was Anglo males that adjudicated cases and the perspective is different. It is absolutely true that we all bring to life our inherent biases and they're not only assigned to race, and whether people acknowledge that or not, it is true, you probably have a special love for accountants that you don't have for non-accountants. You probably have a special place in your heart for prosecutors because we all know they're not all bad people. Most of them are not, but power is a complicated thing. And so the other thing, in light of the conversation we've had, that I've learned being on the bench at the municipal level, preferring to work the jail docket the most, and that's what I do regularly, and it is 24 hours in Harris County, in Houston because we're so big and crime doesn't stop. You have to have a lot of courage to be a judge because the presumption that a judge knows everything that goes on and why is misplaced. The truth is, justice is a ginormous system that's well beyond the apparent boss. The judge is not the end-all, be-all. There are bailiffs, there are court coordinators, there are clerks, there are policies, there are procedures that help dictate how justice is dispensed. And if you're not willing to question that, or look behind that, or challenge it, ultimately you probably won't be a very good judge because if you just do what others are doing or what you think is expected, you may be successful in that you will stay on the bench, but you will be unsuccessful in that you may not serve justice well. And so because I've been a sole practitioner, because I've had a fascinating and wonderful life, I don't get my identity from my title. So I'm knowing that at most this job, if I get it from the public, will last 4 years. And I'm willing to have it or not have it. And that's the freedom that I take to the bench because if I can't go there and be courageous, if I can't go there and take a stand, if I can't go and ask questions, there's no reason for me to do it. And I'm old enough now that the things that used to frighten me don't frighten me anymore. So
let me pick up on something good. When we first started talking, I wrote down courage to follow the law. So I find it fascinating that you used the word that I had written, but the debate got good, so I didn't get back to it. I have quite a few little issues I want to talk about.
This sounds silly. This is something that takes courage. Efficiency is important, right? As judges, you've got to clear your docket. You've got to have it. You've got to deal with your administrative issues. You've got to deal with your social justice issues. You've got to deal with the legal issues. It's a big job. In the municipal courts and in all jail systems in Harris County, when you get accused and delivered to a jail system, your property is taken from you. These days, nobody knows phone numbers.
Nobody.
So if you want to call somebody to help you, to call the bail bonding company, to call 311 if you're in the city of Houston to get information on your case, most people don't know the phone number.
Isn't that crazy? These kids do not know phone numbers. I realized I was losing phone numbers, losing skills. So about 10 years ago, believe it or not, I decided I'm going to start calling my friends.
Okay.
So if I talk to you often, I know your number. Like all the people I call, I know their number because I felt stupid. I'm like, we grew up knowing numbers, and now we don't know them. So I intentionally call people.
Because
is
you
good.
mentioned that.
That
on
is
a
good.
show I have about
I started doing
learn
that.
3 numbers.
Oh no,
teach little kids to learn 3 numbers.
everybody that's in my life, I know their phone number. I know my brothers. I know my aunts. I know my girlfriends.
So here's the upshot. I have to see hundreds of people a night. How long I spend with each defendant, where my job in arraignment is to tell them their rights and make them understand what the circumstances are, what they're accused of, and what this may lead to. And in crimes of moral turpitude, it's really important. But usually when people are in jail, naturally all they want to do is leave. And you say, have to communicate in a neutral way that leaving is not of paramount importance. Of more importance, in my opinion, it might be your record. If you're not a citizen, your record could make a big difference. If you're accused of assault crime with family, that could be a big problem. If it's theft, forget it. It's very important that you do everything you can to defend. But many people think, well, if I just stay for a day and plead guilty, it's no big deal. So back to the point of phones and courage. Efficiency is important. I, as a judge, have the privilege of working with clerks, and I can say to them, can we Google this dude's address or this woman's address so we can see what his phone number is? And then after we Google, can we use our personal phones or the city's phone, depending on where it is, because many people are now in other area codes, to call his family so that he can talk to them through the speaker if they're on video, or hand him your personal phone to talk. Now, that's very generous, but if you do that 15 times a night, you might get behind.
Very behind.
And the jail may call you to say, why are all these people still here? Your boss may call you to say, why are you still on the 7 o'clock docket and it's 10 p.m.? And in general, the clerks may be bothered because that either means lots of work for them, overtime, or explanations to their supervisors, which are the kind of consequences people don't think about. But my approach, my courage, my choice is to always, every single time I can, do whatever is required to give the defendant what they seek because it's logical. To treat them in such a way that I know to be true if they had a lawyer, if they really understood what I was saying, this is what they would do, this is what would be best for them. And I've even called regularly, probably too often, the police department to say, hey, can we get this person's property? Because, for example, if you're from out of town and you've got $1,000 in your property and it's only $300 to post a bond, but you know no one and no phone numbers, guess what happens? You can't get yourself out because you can't get to your $1,000. Now, most people don't consider if we reopened every single person's property, there'd be chaos in the jails. In addition, if we open it and you say it had 1,000, but really it only had 100, we might be subject to your lawsuit that accuses the department of taking your stuff. So there are lots of processes in place, but there's also a way to dispense justice that's logical. So I take the risk. I've had clerks who say, oh, here comes Hall, you know, she's going to be doing everything for everybody. And I've had clerks who said, yippee, Hall dispenses justice. Again, perspective.
Let me stop you, Hall. So when you become a civil judge, a civil district judge, will you have the courage then? It's easier, in my opinion, for the sake of conversation, to dispense justice when you're dealing with the everyday guy on the street that you want to help. But what about when you have this $1 million lawyer in your court and this plaintiff? Will you have the courage to follow the law? And that's what we want. And that might not be popular because they will they will run someone against you. I believe you will, but I would like you to say wherever the law leads you, you can follow.
Absolutely. In fact, I just wrote that in my League of Women Voters questionnaire. When they ask us, what do you do? One of the questions was precisely that. How will you ensure that justice is attained in your court if you are in a circumstance where people may have contributed to your campaign or where you realize you're dealing with somebody with large donors? Well, I would say, and I'm saying it on TV so I can say it boldly, if you give me a contribution, thank you. You'll get your thank you note. I appreciate it. But you're not buying anything. You're supporting a civic experiment in elective politics, and you are supporting me. But what people forget is many people who would give to me are also going to give to my opponent, are going to give to your opponent, and everybody under the sun. It's hedging. So I have seen a colleague of mine from the municipal bench, Judge Kirkland, be unseated for essentially what is doing the right thing.
Right.
So it's very close to me to know that's a consequence, and that's why I say I'm willing to lose my seat. If doing the right thing means I lose, I'm willing to do that.
And I think if you do the right thing in your job and you communicate more with the public, which most judges just go back into oblivion,
Yes.
I think that people understand.
Yes.
If you write good opinions, if
Yes.
you explain it. One of the things I do have to compliment Hazel about, Judge Jones, is that when she got on the bench, she did have the courage to write good opinions. Because that took some time, and you do have to take time to do that because you're never overturned no matter where you go.
If you don't
talk
write.
about, if you write about the credibility of witnesses, the things that judges have been too lazy to do, and I have to mention that her predecessors did not do, so she did research the law and do that, and I appreciate you for doing that. One of the things that I'm frustrated, though, by is the nepotism in the criminal court. I'm frustrated because when I got on the capital list many years ago, we took a test, a very hard test, written by Mary Lou Keel, who was board certified, and she was a judge.
Yep.
And she updated the one that had previously been written by the judge in the 183rd, and I'm drawing a blank. You know, the older man that y'all are letting be on the bench now, y'all started letting him be on the bench. He's affiliated with Shauna Reagan.
Randy Roll?
No. Anyway, I'll think of his name. You know what I'm talking about.
do.
But when you think of it, he wrote it first because he was a scholar, and but then she updated it. So they said all the lawyers have too many capitals. They all have 15 or more. Guess how many I had?
None.
One that I've had for like 5 years.
Yeah.
One that I've had for 5 years. And they put everybody on the list, all their friends on the list last year who have no capitals. Now, new lawyers have only been lawyers 6, 7 years, never took this test, never chose to, even 10, 15 years, they never chose to take the test. Now they all have 10 and 15 capitals. And you know they're representing minority, black and Hispanic people, mostly black, and none of them are black.
Yeah.
You said
I
none
have
of
a
them taken the
personal.
test?
They abolished the test because too many of
remember
the
when they
Anthony
tested.
Osos and the Skip Cornelius, who I love these guys, they had too many. They had too many. So when you have too many death capitals, you know y'all have a problem scheduling.
Right.
Because, you know, death capitals take 3 months to try.
Sure.
Well, they take 3 months to try. So if, you know, a lawyer wants a break in between, and so if you have 15 of them, that means you can probably only try 2 a year. You know what I'm saying? So that means that these guys are not going to have their trials for 5 and 6 years. You see what I'm
I thought
saying?
the issue was the attorneys didn't want to take. A lot of attorneys didn't want to take them because
The
it
list-
follows you forever. And
That's
it's
why
not
that's why I'm educating you on that. The list is long.
Okay.
The list is long. The people that are appointed are few.
Yeah, and I have
On the capital list, if you pull that list, there might be 50 lawyers on there, but it might be only 10 that have all the cases.
Wow.
And so I'm just telling you, they only put about 10 or 15 more of their friends on there. All the ones that left under Pat Lycos, and some of the other ones that got fired. Those ones. And why couldn't they take the test? Even if someone updated the old test. I mean, why couldn't they? At least Harris County always could say that they went through
Had
this
some standards.
rigorous. They had some standards to court appoint
Definitely.
people. And now, I mean, and there's some of the people that they've added to that test who did very unethical things in trials that I've beat in murder trials, that had a witness testify that they jailed to testify against my client. He testified, said he hadn't had no felonies lately, even though he's in Orange. At the break, he's gone. I cross him, he's gone. He's a pivotal witness to their murder trial. I go in the audience and they say, oh, that guy just got out the feds. Just got out the feds. It was in the 337th when Richie was there, so you were there. Just got out the feds. And I said, wait a minute, Judge. I asked the prosecutor and the chief, can y'all give me his NCIC? I realized y'all didn't give it to me. They had written on there, do not give to the defense. He had just
Wow.
gotten out 6 months before. And I made, Cheryl Irvin ran through, I said, make a copy because I'm about to make a bill on it. And I did because, I didn't know if I was going to win or lose.
Right.
The judge said, well, the prosecutors did nothing wrong. Now, it's written on the NCIC.
Right.
And that's what I hate about, and this is a Democratic judge who got elected on Obama. Why help them like that?
Yeah.
Well,
Wait, let me just finish the story. So the judge allowed me, I said, well, to correct this measure, let me call him back to the scene. And I called him back on to the witness stand, even though we had been finished with him, impeached him on it. He turned his back on the prosecutor and said, and yeah, they made me testify like I did. You know we won.
Wow.
Because he was pivotal. Because he
And brave.
And brave. And because they had also done had to give me a Brady notice because he had recanted. And they arrested him. So I'm just saying, the courage to do the right thing.
And
Now,
when you
you
have all
know
the
they should have been
tools, why do you
sanctioned for
cheat?
that.
Right.
Why do you have to cheat when you got all the tools?
That's
You're
why
the
elections
presumptive
are
winner.
important.
Yeah.
And not being fearful because you become a little group when you come down there. You're going to have the same lawyers in there all the time. And you become a group, but you still have to have the courage because that's not your job.
I don't. That's a.
And I watched courage, so that's why for me and some of us running, and I'm not saying you did, because we actually watched judges have courage and still be respected. Because they demanded respect.
Right.
They ran their courtroom. They were there on time. They stayed late, and they demanded
Worked
respect.
on Fridays.
Whatever. They just demanded. But they demanded respect. Everyone respected them equally. If they were mean, they were mean to both sides. And I would like to see the judges be the gatekeepers of the Constitution once
be
again.
nice.
Yeah.
So we know as
some
lawyers
fair
and citizens.
evaluations by the Houston Bar, the people that screen the judges, fair evaluations on those bar polls that they have the public relying on. And so I think those bar polls need to definitely indicate to the public that they are not reliable in the sense that there's no way to evaluate who actually is completing these polling.
Something like less than a tenth of the bar population
Right.
participates.
They need to make sure they let the
Statistics are aware that the statistics on participation.
because it's misleading to the public. And I think that's important because, when I was on the bench in 2008, I tried my best to be fair and impartial. I tried, and I believe I was. I followed the law. I wrote as
you should have given me a few
Vivian.
more capitals, but
We only had one, Vivian.
you didn't give it to me. You should have.
So,
Judge, can you highlight too, both of you, since you've asked and mentioned it, writing, most people don't understand what that means. If a trial judge doesn't write an opinion, there's nothing
to appeal.
to track,
Nothing to
appeal.
track their feelings.
So expound on your choice to write and what it means.
It's important for you to determine what really happened. And so you want...
And who was credible.
Right, and who's credible. So you want the courts to know how you arrived at your decision and what the facts were. And so a lot of times when I was a prosecutor, the judges relied on the state to determine what the real facts were in the hearing. And so I thought that it's the judge's job to make those determinations. They're making the final
But
decision.
it's hard because if you avoided doing that, there's less basis to overturn, less basis to evaluate.
Right.
So it's courageous because it's creating for your own actions a record.
Right.
And one of the things I admired Hazel for doing that, and I went around, I just want to be clear to all the new Democrats and ask them to do that. You were the only one that did it. And I appreciate you for doing it. But the other way to do it, Ramona, when you win, if you don't want to spend the time, Hazel would have law books out. I mean, she was working it up. But if you don't want to, you can always, like the old school ones that I was a prosecutor with, they would talk it into the record and make their court reporter write it up. So
I've done that once.
Yeah, but I'm just saying. But I'm just saying sometimes.
Efficiency is important.
But sometimes, because sometimes you can just take the law from both lawyers and just decide which one you want. I mean, Hazel did it the more cerebral way. She was actually studying the law on her own and coming up with it.
That's part of the job.
Right.
That's part of the job.
And I want us to do that. I want you to do that, and then whoever wins, I will be encouraging y'all to do that and be available and encourage in those judges meetings that they are more representative of the community, because what you mentioned, the STAR program and all those programs. I've been a community activist for years. Everybody knows me as a community activist. I started this show and I pay out of my pocket for it so that I can bring education to the community. But they don't have people like me at the STAR program. They don't have me. I mean, they have all these programs.
The STAR program.
Right. Well, all
your church is not the church that gives them the money to do the rehab.
for mostly black kids.
Right.
And so, and they know that I'm not asked to do any of that. And I think that's insulting because I give a lot to this community. At least 3 nights a week, I'm going to be somewhere speaking tomorrow night for free. I represent people pro bono constantly.
Definitely.
When Reverend Nash calls me. But it's very, I'm just going to say this openly. It's insulting to me that people know I'm an advocate. And I am
a good lawyer, more
And a
importantly.
good lawyer. And I am ignored for my advocacy. When these programs come, the same lawyers who have contracts with the courts, and then all these different people who let the judges use their chateaus and let them use their
Relationships are important.
relationships
Extremely
are important. But the thing is, I mean, we all have relationships because we're all a big family down there.
Perhaps
but I'm
you shouldn't be
very
insulted
undermining.
because perhaps is there a possibility that you're not consulted precisely because you are good, precisely because you are
But
courageous?
isn't that terrible?
Yes.
That we wouldn't want the best for
Yes. But isn't it
for the
typical?
downtrodden, because that's what I'm
Isn't
an
it
advocate.
typical for those in
Diversity is very
power?
important.
And
That's
let
why
me say what I
diversity
say
is
on my show
important.
all the time that you might not be aware of. I am the people I represent. I mean, I think God put me here for a reason.
I sent you referrals. I know what you are.
Yeah, but I'm just saying, I was raised in family foster. So I don't come from a loving environment. I stand alone. And so I understand the battle that a lot of these people are going through emotionally and psychologically.
Strength and competence are sometimes the problem. So your insult should probably be non-existent.
Well, I just want to share that because these are future judges coming up. Because for some reason, even the Democrats, when they won in 2008, they still gave the capitals to the same old suspects.
I know.
It was all the people, and I was campaigning my butt off for y'all.
And I want to speak about that because I have a personal experience
Yeah, you
about the
know
court
that.
appointment system.
Yeah, the
You
court
know,
appointed
when I
system, it's not
ran
right.
for court in 2014, I had been on the court appointment list since I left the DA's office.
Right.
No incident, never had a problem.
Right.
The person who I ran against was extremely angry, and she let me know it. Okay.
As in the incumbent.
Yes, very, very
So no
angry.
more appointments.
Okay, so I didn't get any more appointments. I was told that I wasn't going to be getting, but she waited until I filed for this court, and then I received a letter stating that I was no longer ever eligible for court appointments.
And she shouldn't have that power.
No, she shouldn't.
And you're
Imagine that.
as qualified
No,
as
she
you are.
No, she shouldn't. But it just undermines again the system and why I am so personal. It's like a personal vendetta for me because I already knew that it wasn't working properly. But then when it happened to me, there's no way that I'm going to allow that to be done in my courtroom.
Yeah.
You know, and so I really believe that.
And let me just share something else with you, with the three of you. In those old days, judges constantly complimented the good work of lawyers from the bench. And that was something I was going to do at least 5 times a day. Because you as judges, when you're sitting up high, you see the lawyers coming in and the ones who are getting the work done, who are after the DAs about what they're supposed to be doing. I write on the reset form so everybody knows. So you know who's working hard. In the old days, they would just say it. And when a judge from the bench says, you've done a good job, that's 3 or 4 people that's going to hire you when they walk out that door. And we need to support each other in that regard if you think they did a good job, you know, and compliment instead of the nepotism of all of these lawyers who have contracts that just come to work. They feed off of this system.
And they're going to be extremely angry when we get elected. They're going to be extremely angry because it's going to be stopped.
Many are angry at our candidacy.
That system is not going to continue. You know, I looked at.
But like I said, they don't contribute, but yet they get the $100,000 cases.
Right.
And that's not fair because that's what a lot of those judges did. Like, you know, I love Mendoza. I love Guerrero. I have had them all on. I've worked hard every time they campaign, and I don't get those. But all the Republican guys are the ones who get all the cases. Look, I mean, if you
were you on the list? I don't remember.
I've been on the list since you became a baby. When you were a baby prosecutor.
Wow.
I took the test when we were in the old building. We've been in that building since January 2000. I took it under.
Just not
that's why I
coincidence.
can't think of his name.
No, it's not by coincidence.
It's not by coincidence.
It is policy and decision making.
Yeah, it's policy
by the elected people.
And y'all have to
And
have the courage to
favoritism.
speak up for us because they're loudmouths, and you can say because I'm a loudmouth. Anthony Oso's a loudmouth. He's a good lawyer. He's the one that's representing the guy that killed the police officer, the black guy. I'm just saying, but he's in the 208s on all the cases. I'll only get a capital if he has me as his number 2. Now, the only one I've had pending for 5 years is from Vanessa Velasquez, and there was a problem with his prior DNA. He's doing a life sentence from the 80s, and the DNA came back not his.
Wow.
Okay.
But so they had to send him back, and so because they might not have to seek the death on him because with the new law where they can retest the DNA, it wasn't him.
Right.
Many people would be surprised to know that in the state of Texas we don't have any evaluative standards for judges. There is no performance review. So when you mention the bar, when you mention how people can effectively what you're saying is get away with the things they do, we don't have any overseeing body. And
we don't sometimes respect our older judges. I hate to keep butting in, but I never have been about this, but I'm in a 3-week or 5-week trial sometimes. It's because I am 58 with no exit plan. Everybody else has an exit plan, and I don't have one.
That's
Everybody down there has an exit plan. They can be off on Fridays. I have worked 7 days a week all year. I mean, I'm almost in tears. I'm exhausted.
But
I was
this is
throwing
the side
up going
that
to work
people
Saturday.
need to see
I
because
was
they
throwing up. I had to because the case I'm doing now I got paid for last year. I have 3 people at my office, and to meet somebody at 10, I haven't slept. I have been working nonstop. This is my
the life
since
of a
July.
sole practitioner.
This is my 3rd federal trial, and I've had a state trial since July, and this is September, and I started this on September 19th.
You look
That's
good
a lot.
too.
That's a lot.
Well, I'm just letting you know.
'Cause trials are
Daniel,
very
who was in there,
draining
know when I got to
mentally.
work at 10 o'clock on Saturday to meet a potential new client, I was vomiting.
Yeah.
That's how
'Cause
tired
it's
I
draining.
am.
So mentally,
practitioner.
it's exhausting.
Yeah,
Definitely.
But a lot
But
of
it's
sole
more than
practitioners
just
don't.
that,
It's more
too.
than that because
It's
people
more.
only come to a woman. My niche is trials. I can't do the people who want to plea. They come to me for a trial. So when you see me, prosecutors are angry, but I'm their second lawyer. That's just my niche because I actually do fight for people. So I have a heavy, heavy trial schedule.
Right.
And all the lawyers in this case do, luckily. And so the Judge Werline gave me something we'd never had before. We have a protective order. Have you ever seen a lawyer with a protective order?
No.
A month before the trial, he gave us a protective order to last on the day it starts until it's over, for us not to even have no problem giving it to all the judges.
Okay.
Isn't that a trip? But anyway, so I'm venting, I'm sorry. But I just think that age and maturity and sacrifice should have some privileges. And I see young lawyers being
Absolutely.
treated in a way, and they wouldn't do anything for you. You know what I mean? It's just
Right.
tiring that, because it's like when we get our Democratic judges in, they fall into the same old routine of what they see their predecessors do, which is not fair and it's not right. But it is getting time to close out. So let me come on, Hazel. Let's talk about what's on your mind.
It's on my mind.
Because I know you got some
of
things. I know you.
That's
Well,
a
what can
lot.
you say in about a minute and a half?
Well, this race is very, very important. As we all know, this, as you heard during this conversation, judges can make a very great impact just on policy and things as it relates to who is the attorney that's going to represent someone that's indigent, that needs excellent representation. And so we want to make sure that the public is well aware that they have some excellent candidates in the Democratic slate this year. I was endorsed by the Houston Chronicle this year against my Republican opponent.
Yay.
I believe that my years as an attorney, going on 20 years in November, trying cases in federal court and state court, criminal cases, being a district court judge, says a lot about electing a juror who can be a fair and impartial juror and can best represent Harris County. I think we have a lot of issues to address. Clearly, we want to make sure that we have judges that are approachable by the bar, but we want to make sure that we elect judges that are going to do what they think is right and are going to follow the law wherever it leads. And that was what I campaigned in 2008. You look at my campaign literature, I said I will follow the law wherever it leads. And I think as a judge, I did just that.
Yeah, you did.
But sometimes that doesn't make you popular with people. Unfortunately, I realize as a judge, nobody wants to be fair.
Right.
You say we want to be fair, but people aren't really happy with fairness.
That's what you realize. People don't want fairness, and prosecutors to their benefit. And prosecutors don't want fairness, and they're used to winning. And I'm just saying there wasn't always that environment, so it can change. Let me let you have your minute and a half, Ramona.
Okay. Wow. I'm stumped, but I will say again, this is just such a critical election.
And why is straight ticket so important?
Straight ticket is so important because, as we talked about all of these issues, they're not going to be resolved with the current judges that are on these benches, right? Because if that had been, we wouldn't even be discussing these issues, right?
Right.
So if you're having a problem with sentencing disparity, like we talked about, fair bonds, then you need to vote the straight ticket. I mean, for Democrat. I mean, it's not even an option. It's very easy, right? If you
don't believe the hype. There have been years where there have been said if you vote straight ticket, Obama won't win.
Oh,
don't believe the
God,
hype.
please
It's designed
don't.
straight ticket. You can have the last word, please.
Thank you for letting us be here. It's a wonderful opportunity. It's generous of you as a former candidate and a fantastic practitioner to allow us the opportunity. You opened talking about the Year of Women. I literally just returned from Wellesley College, which happens to be Hillary Clinton's alma mater, where I was president of the debate club, president of the student body, many things that Hillary Clinton was. So I was a fan of hers as a person. I'm not making a political commentary, long before Bill was Bill. And there is magic to having women who are courageous, who represent diverse populations, be a part of the leadership system. It's invaluable, in fact. And while all are not created equal, we are not a monolith because we share skin color or gender. I bring judicial experience, over a decade on the bench, so all the things that are required of a judge I already know. Intellectual integrity, I believe in hard work, I believe in scholarship, I believe in fairness, I believe in integrity.
So all we have to do now is get out the vote.
And straight Democrat ticket.
People, let's get
Definitely.
out the vote. Thank you, ladies, for coming on. This
Thank
is the year of the woman. I will do my. I will. Yay! I will do my part to fight for you, and
Thank
I will
you.
continue to talk about it. I'll continue to send out messages. Thank you for being women, to have the courage to fight a system. I know it's like David against Goliath. Thank you. Thank you for being our Davids. And thank you for watching Truth and Justice with Vivian King. Good night.
Thank you, Vivian.
Thank you. Great show.
Yes.
So I'm going to give y'all some tape.
Tonight we have something